Welcome back to Rationally Based, a podcast about law and politics on the edge. Kathryn, what's on deck?
Well, first, we're covering all things immigration. We have updates on the Kilmar Abrego Garcia case, more on Trump's attempt to end temporary protected status for Haiti, and finally, attorney's fees for illegals. Then we'll cover Trump's executive orders targeting law firms. And are they legal?
Let's dive in. I'm your host, Ilan Wurman, a law professor at the University of Minnesota Law School.
And I'm Kathryn Johnson from Center of the American Experiment.
And we are joined today by a very special guest, Will Chamberlain of the Article 3 Project, and I believe also the Edmund Burke Foundation.
Yes.
Will, we are very excited to have you here. Why don't you briefly introduce yourself? Tell us who you are.
Yeah, I'm Will Chamberlain. I'm a lawyer. My primary gig is senior counsel at the Article 3 Project. The Article 3 Project is a political and legal advocacy organization. We're out there trying to get judges confirmed, get President Trump's nominees confirmed, and push various causes through Congress, and also pressure judges, even from the externally to make the right decisions in general. I joke sometimes that my job is to bully people, but that's not very formal. We're an advocacy organization. We do a lot.
And you bully judges.
No, sometimes senators, judges. I mean, it depends, But bully is obviously the aggressive way of saying that we are going to make aggressive arguments about why you should do a certain thing, and then also, put out ways for our followers to do similar bullying by emailing their congresspeople, for example.
Well, we are so excited to have you here. And you're also pretty much an expert on immigration law. You've been writing and thinking a lot about this. You've been out there. And so today we have 4 immigration topics that we're going to talk about. Not birthright citizenship, though if we talk about that, that would be great as well. Our audience who watches us will notice that this is our first episode on Zoom. I'm actually here in a hotel room with this beautiful bedspread behind me. I'm here in D.C. because I'm going to be testifying in the Senate Judiciary Committee, the subcommittee on the Constitution, on birthright citizenship. And we've promised our viewers so many times already a deep dive into birthright citizenship. But we've got so many other topics we want to cover today with Will, who again really knows his immigration law. And so I think we're going to start. Kathryn, what do you think? Kilmar Abrego Garcia? Is that what we
Yeah, let's do it. I was going to say one other thing about Will is that he's like the best X follow. So if there's even a single person watching this who doesn't follow Will on X, highly recommend it. One of the things that you've talked a lot about, Will, is this Kilmar Abrego Garcia case. He is the Maryland man, right? Like one of the OG things that people were using as an example of it's so bad what Trump and ICE are doing. So will you start at the beginning for us, kind of like how he got on the scene, where that started, and where it's gone from there?
Right. So this is go all the way back to April 1st of 2025. So almost a year ago now, when The Atlantic put out an article about the Maryland father who had been wrongfully deported to El Salvador, and it was seen as this massive injustice. They described him as having a protected legal status in the United States, and therefore that he, it was a complete injustice to remove him to El Salvador. And from the beginning, this was framed pretty dishonestly, I thought, because he was found removable. He was an illegal alien. I mean, the story of this guy is he crossed illegally sometime in 2011, was picked up in 2019 in the company of known MS-13 gang members, found removable, and then was given what's called withholding of removal, meaning that you are basically, you're still a removable illegal alien, but we're not going to remove you to one particular country because you have some claim that you are going to face oppression or persecution if you return to that country. But that doesn't mean you can't be removed anywhere else. All it means is you can't be removed to El Salvador, which is his country of origin. And just off the top, there were sort of a bunch of reasons why this is sort of ridiculous. El Salvador under Bukele is no longer a dangerous place where you can reasonably say you fear persecution, or at least unlawful persecution. I mean, he might find himself back in CCOT because he's an MS-13 gang member. Very likely an MS-13 gang member. Let's put it that way.
Alleged.
Actually, no. Here's the funny thing: the immigration judge found he was an MS-13 gang member. That was something that happened early on. They tried to the district judges in this case tried to work around this and say, oh, they didn't have sufficient evidence. BS. That's a whole other thing. we can talk more broadly about the problems of the immigration bar that I feel like this case is a microcosm of, where, because I feel like the immigration bar thinks they're acting like Robin Hood and doing fundamental good, they're willing to play fast and loose with some of the facts that, in their briefing. I found that to be the case when I was reading through the filings in Abrego Garcia.
Oh, it's okay. I wanna seize on that, but first, for our audience, let's get your CLE, continuing legal education, in. So, Will, you mentioned something about a withholding of removal as opposed to, I guess, asylum, right? So,
Yeah.
the standard for withholding of removal is actually the same standard, or at least the grounds for withholding of removal are the same grounds as for asylum.
It's
The
actually a higher
difference,
bar.
it's a
It's a,
higher bar. Okay.
it's a higher bar, meaning you actually, I think what the judge has to find that there is a probability, like a more than 50% chance that you will face persecution or oppression, where as the asylum bar is not that high. The idea being that, a reasonable probability is sufficient for asylum. The reason that he couldn't get asylum is because you're time barred from making an asylum claim if you don't make the claim within 1 year of crossing the border.
I see. So he could possibly have gotten asylum, which is also crazy to think about, which I guess we'll talk about that in a second. But he possibly could have gotten asylum because for the same
15
grounds.
years ago, right? He's been
Yeah,
here for 16 years or so.
yeah. If he had made a claim for asylum by 2012, he could have. But I mean, he crossed outside of port of entry, and again, the guy was understand what was this guy doing in the United States? If you've actually ever seen his clips, he's speaking in 2025, having lived in the United States consecutively for 14 years, and he doesn't speak a lick of English. What is he doing here, right? How is he making a living? Well, the answer is, the probable answer is he's a member of MS-13, and he was caught in Tennessee, basically ferrying illegal immigrants from Texas to Maryland. The guy works for the gangs, for the cartels, and that's his job. And so he's not actually involved in the broader economy. He's not even working under the table as some sort of day laborer.
So I suppose my question is, what is the connection of gang memberships to asylum? Like, how could he have ever even applied for asylum? So first of all, the grounds for withholding of removal are actually the same as the grounds for asylum, right? But he missed the asylum train. So if he had been granted asylum, he would have been allowed to stay in the United States. Right?
Right.
Because that's a grant of asylum. So he missed that train because he didn't file on time. But he could still file for withholding of removal to a particular country. So you can't stay here, but we won't remove you to the country where you think you're going to be persecuted, right? Do I have that distinction between
Yes,
withholding and
you have
removal?
that right.
Okay.
Yes.
And the grounds for withholding of removal, although the bar is higher, is the same as the grounds for asylum, right? Namely, persecution, or a central reason for the persecution. So you're being persecuted, and the central reason for that persecution is some protected characteristic, right? You are being persecuted because of a political opinion, because of your religious affiliations, because of your ethnicity or your nationality. None of which applies to Abrego Garcia, right? So it's this fifth catch-all. Not catch-all, but it's or membership in a social group.
Right.
So explain to me what the heck that means. And so withholding of removal because he's a member of, is it because his family's being targeted?
Yeah,
Is his gang the
they're
social
characterizing
group?
it as his family. I mean, and this is where I need to, go back and do my reading on like what social group should be. Like, what did they actually mean when they wrote this legislation, and, the proper narrow interpretation. But certainly the immigration judge, and I believe the law in this area was actually interpreted really broadly to basically mean any group that you could conceivably be persecuted on the basis of. And the way that his lawyers framed this was, well, the reason he would be oppressed if he returned to El Salvador is because the 18th Street Gang, way back in 2011, was trying to extort his mother's pupusa shop, which apparently was the best pupusa shop in all of San Salvador, or a very, very good one that all the neighbors loved.
What is a pupusa?
A pupusa is a Salvadoran, I think it's like a tortilla and cheese concoction of some sort. I've never had one, but it's like I think it's like a stuffed tortilla. So it's not like a taco or a quesadilla necessarily, but like it's actually in there. And I think, and it's a thicker dough than a tortilla, right? So is my understanding. So something more like a torta dough.
Well, you've clearly researched it because that's a pretty good answer.
Not off the top of my head, but I just recall, I recall what pupusas were like. I think I had one once.
Okay, sorry, I distracted you. So she had a very good pupusa shop, and she didn't pay money to the gangs,
the
or
18th Street
extortion?
Gang, which is one of the two big Salvadoran gangs, or was prior to Bukele. One of the two big gangs was extorting that pupusa shop, is the story that Kilmar Abrego Garcia was saying. And so as a result, he was being threatened. He had to leave. And he was said, if I went back, I would be persecuted because the 18th Street Gang didn't forget the lack of protection money being paid in that circumstance and was going to go after him. Now,
But wait, so and Kathryn's giving this facial
Well, I
expression.
just like what's the Americans what is our why do we care? I don't mean that sounds kind of like, but really, why do we get involved in the gang violence or the disagreements that go on in other countries? You can't come here necessarily. There are lots of other places you could go. But is there I guess maybe that no one knows the answer. But why do we get involved? Why do we care?
well, so there actually is a good reason, and it actually has, when it was implemented. I mean, so this actually you have to go all the way back to kind of the history of the Salvadoran Civil War back in the 1980s, when there was actually a really brutal right-wing dictatorship in El Salvador, and people were fleeing it to come to the United States. That's sort of the origins of why we started to have a real Salvadoran community in the United States, was people fleeing the Civil War. And when we started turning people back, because maybe they weren't eligible for asylum for this reason, so we're like, okay, well, then you have to go back, and they'd go back and they'd get killed. And so Congress, in its wisdom, was like, okay, even if they're not eligible for asylum, we need to not be completely horrible here, and ensure that they're not being removed back to a place where they can reasonably expect that they're just going to get murdered by a terrible regime, especially because they've now come back because they fled. So that's the reason the law was there in the first place. The problem is that it's now become this overwhelming, it's become a loophole for people who otherwise would not be eligible for asylum. And we can get into the detail. I went to, Ilan was there for my speech at NatCon when I went into detail about the reason why this became a real problem is because of the Supreme Court case called Zadvydas v. Davis. Which
I do want to talk about Zadvydas, because that is part of the reason that Kilmar Abrego Garcia has been released from detention now,
Yes.
right? Because the federal judge basically crazily says there's no plausible way you're going to deport him somewhere, which is also like weird because you're
wrong on the
deport.
facts. Wrong on
Right.
the facts. She's
And
playing
so
a lot
this-
of games here.
So there's this due process concern in Zadvydas, right, is the case. But before then, I want to go back to Kathryn's question. So Kathryn's question, by the way, this is why we have you here. Why do we even have asylum?
I like the answer. That makes sense.
Mhm.
It's just hard when you think of we can't do that for everyone, of course.
Right. But
And so
as much as I want to.
So it seems to me that the purpose of the asylum laws isn't just to bring in people from terrible countries where the economies are bad or there's a general failure of civil society and government functions. It was very specifically after World War II, this idea, and that's where the Refugee Convention comes from, that, okay, targeting Jews because they're Jews is bad. Targeting gypsies and gays because they're gypsy or gay is bad. It's this idea that if you target people on some widely shared characteristic that is somewhat out of their control, or that they shouldn't have to control, like your political views, that is something we cannot tolerate, and we will open our doors for that. Now, maybe we didn't have to do that. Maybe that was a mistake, but it seems to me that the real problem is the way the immigration laws have since, as Will said, been interpreted and broadened. So, for example, here, again, this is not a World War II persecuting Jews situation. This is, so Will, based on what you said, I see two problems. One, it's not the regime targeting him. It's gangs targeting him. And maybe the regime is incapable of stopping it, but that's very different than the kind of persecution we're talking about. So that's one problem. And then the second problem is, again, this idea your family pissed off a gang, and so now they're targeting you because you are a member of the family. That seems very different to me, and I can't really put my finger on it why. But that just seems very incongruous, relative to the other, your political viewpoint, your ethnic and national origin, your religious viewpoint. The fact that your family pissed somebody off and now they're going after you just doesn't seem like it fits. I can see sort of, it's not. If you didn't piss off the gang, but they're going after you anyway because you're a member of a family and you can't control which family you're a part of, I sort of get it, but it just seems so different, doesn't it? Than
and I
political.
think the other big problem is it's so horribly unverifiable, right? You can just kind of make up any cockamamie story, like, my mom's pupusa shop was being extorted. It's just, as a result of the fact that a social group can be such a small thing.
So in going back to the gang thing, then, is the idea, do you have to show in asylum proceedings or withholding of removal proceedings that the government is encouraging the gangs or a part of the gangs,
No,
or
just that you're being oppressed by it, and moreover, your testimony, you don't even need evidence. Like basically, there's if you read through the immigration judge's opinion, it's this is not the first time this has come up, and they basically say, yeah, because asylum applicants often are not in a position to provide substantive evidence to prove their allegations, the immigration judge is just allowed to take their word at face value about the sort of oppression they'd face.
and that's why credibility findings are sort of important. Like, do you
Yeah,
sound good in front of the immigration judge or not?
yeah, but then I mean the problem is that that's a huge amount of discretion in the immigration judge, and I mean one of the things there's a lot of reasons to think that especially given that Mr. Abrego Garcia's story changed from April to September in 2019 when he had his
Okay,
his hearing on
that's
this.
what you xed about. What do we say now?
Yes,
Tweeted, posted, X?
Posted?
posted. Yeah.
Posted. Okay, we don't say tweeted anymore. So that's what
Mhm.
you posted about on X, so we'll come back to this question of Zadvydas and can we deport him somewhere or not. But your claim was even just on the withholding of removal, he totally changed the story and was clearly making this up. So you posted something about this and no one else seems to be talking about it. So tell our audience, what is it that you uncovered in the 2019 proceedings with respect to this withholding of removal order?
So basically, in a filing back in January, the DOJ included something that hadn't been in the record before, which was the transcript of one of his very first hearings in front of an immigration judge, where he was asked to, didn't have counsel present, was just asked questions with a translator about, what he was worried about. Did you cross legally? He concedes, no, I didn't. Are you afraid of anything? Which country would you like to be removed to? And he actually said El Salvador, which was interesting.
Which country he wants to be removed to? Or
right. So he basically at first he was saying, oh, El Salvador is fine. I can be removed to El Salvador. And then the judge asked him, well, is there any reason you wouldn't want to be removed to El Salvador? And he's like, well, they're saying I'm a member of a gang. I'm worried about that. And that was his answer. And it's sort of like, yeah, in his shoes, he'd think like, yeah, if you send me back to El Salvador and you're saying I'm MS-13, that would be a problem for me when I'm back in El Salvador. So I'm worried about that. And then in response to that, the judge was like, okay, here's the forms, you fill out the forms and we'll come back and we'll do your danger hearing to figure out whether or not you're eligible for asylum or withholding of removal. And then, so that's what he said in that first hearing. And then 6 months later, fully armed with the forces of our wonderful NGO immigration lawyers, he has this new story about the pupusa shop and his mother's, being persecuted by the 18th Street Gang. None of that was, when he was asked point blank, what are you afraid of in El Salvador? None of that appeared in that transcript.
Wow. Can I ask you a question?
Wait,
Oh,
I have a
Kathryn.
solution to this. I have a solution to immigration court. We need an American, an actual American to argue the other side. How come there's no one being like, okay, this guy, pro, maybe he has good pupusas. Okay, that's a pro, maybe for his local community. Con, gang member. Okay, that's a con for Americans. And then we weigh those things from the perspective of someone who already lives here and is an American. Wouldn't that solve this issue? I feel like this is all so,
this is a product of the incompetence of the immigration lawyers in this case. This wasn't ex parte. There was somebody representing DHS at these hearings. Just didn't do a very good job.
Okay, so that exists. There is someone who's supposed to advocate on behalf of the American person. I just always hear the side of the immigrants, and I think, well, that's one side, the Maryland father, and then you get the other side, and it's not.
Well, they're not allowed, Kathryn. They're not allowed to talk to the media, are they? Right? I mean, what DHS line attorney is allowed, or immigration lawyer is allowed to talk on the side of the government is allowed to talk to the media. So that's sort of a big, disadvantage that they have. But it sounds like, Will, you mentioned the other disadvantage is that, well, so if Kathryn, this actually does illustrate something interesting, which is even though DHS has lawyers, well, if they don't have to prove their claims, if it's just like, do you sound believable? What is the DHS lawyer like? Oh, I went to the pupusa shop. Like, no, I didn't go to the pupusa shop because I'm a DHS lawyer in the middle of Texas. Like, I'm not going to go collect evidence. So it just seems like these proceedings aren't really geared toward gathering evidence of a serious kind. So, maybe that's one problem. But the other thing I wanted to ask you, because you got close to saying it, and I don't want to force you to say anything you don't want to say, Will, but immigration lawyers, NGOs, do you think they're coaching their clients to lie? I guess
yes, I do. I do. 100%.
Tell me more about this.
So, it's a combination of looking, honestly, you just look at this case and you say, here was his story. He could have mentioned something about this pupusa shop or about being persecuted by a gang, but he was worried about being labeled a gang member. And then 6 months later, he suddenly has a story that can very, very conveniently fits into existing precedent about what would allow him to stay in the country. I'm sorry.
And
Like,
this
I think
happens
I know what's
often.
going on here. The other thing was actually, this goes all the way back to April 2025 when I was just going through the original filings that the lawyers were making for Abrego Garcia in court, and finding things where they were being really slippery with the facts, if not outright dishonest. So a really good example of this. There was a claim made in the original complaint that was then echoed in both the district court opinion from Judge Zinnes and the Fourth Circuit opinion affirming it. That DHS was claiming Abrego Garcia was in the MS-13 gang and he was a member of the Westerns Clique. And the reason that was implausible is because the Westerns Clique operated in New York. That was the original claim. And then the judges interpreted that as the Westerns Clique didn't operate in Maryland. Where I believe he got this from is I just looked at the DOJ website and Googled Westerns Clique MS-13, and the only results on the DOJ website came up from this one case in New York where somebody was a completely unrelated case about somebody getting murdered who was a gang member in New York as a member of the Westerns Clique. But then I did more research on it and found, yes, of course, actually, there was a massive RICO indictment in the DC metro area of MS-13 gang members, and the Westerns Clique was an obvious and notable part of, was operating in Maryland where Abrego Garcia was. So I don't know if this lawyer was just outright lying about it or being deceptive in the way he framed it, but basically, this meme that the government's clearly lying here, the Westerns Clique doesn't operate in Maryland, it was just blatantly false and disproved by overwhelming evidence of, a RICO investigation that a bazillion people pled to.
Now, the lawyer said this in court, or was this in the media?
Here's what the lawyer said. This is what the lawyer said to avoid a blatant act of dishonesty. What he said was in the complaint, he said, statement 1, DHS has said that Abrego Garcia was in the Western Clique. Statement 2, the Westerns Clique operates in New York.
Well, that doesn't mean they don't also operate
right
in Maryland.
But that's the implicate. He let the court believe in this this implication that is false. That's a false.
And Kathryn, go ahead.
Just to be clear, the lawyers, these NGOs, they get government funding like crazy, right?
I'm pretty sure they do. If not immense, big money funding from the liberal billionaires. I don't know how much government funding they get, but I assume they get some.
My students who are watching will know that the canon of interpretation applicable to this situation is the expressio unius est exclusio ulterius canon of interpretation. The specification of one thing implies the exclusion of other things, similar things that aren't listed, but it's context dependent. So simply saying that there are gangs in New York, unless there are other reasons to think that you are analyzing the whole country when making that statement, the expressio unius statement probably shouldn't or the expressio unius canon probably shouldn't apply to that situation. But okay, so immigration lawyers maybe not lying, but get lots of money to coach their witnesses and to walk right up to the line, which is so fascinating because people accuse the Trump administration lawyers of constantly, misleading the courts or walking right up to the line. Does anyone attack immigration lawyers for this? I mean, there's
apparently I'm the only one who thinks that there just needs to be this mass. And I mean, just this one case, you go through this one case and you get in the filings and you realize these guys are playing, these guys are these are ethical violations. These guys are playing really fast and loose with the facts and really fast and loose with their representations to the court. And as a result, you have, two courts who adopted your, who actually used your canon of statutory interpretation, right, or the canon of statutory interpretation, and put false claims in their opinions.
So let me stop you there because this is a good segue into the Zadvydas case. Because my understanding is we can't remove him to El Salvador, and you said that order is ridiculous anyway. But putting that aside, the withholding of removal order is there. It doesn't mean we can't remove him to other countries. And I think the Trump administration was trying to remove him to various countries in Africa, I think.
Yes.
And for whatever reason, we couldn't do that. And I'll get back to that in a second. And so then the judge in this case said, well, you can't plausibly remove him anywhere. There's no prospect of removing him to all of these countries. And you can't detain him indefinitely. That's the Zadvydas case. And so we ordered him released. And that's the newest thing. But before we get there, so my question is, why can't we remove him to these other countries? my understanding is that he was making CAT claims, Convention Against Torture claims in all these countries. How can the lawyers plausibly know that he, who has never been to this country, would be tortured in these countries that I don't know, like is you explain it to me, right? Like it's in other words, what I'm trying to get at is it sounds to me like the lawyers are coaching him to make cat claims or outright lying and without any basis of knowledge, just saying, "Oh, he'll be tortured there." Like where do you get that from, or are these lawyers lying? So let's start there about the removal to third countries. Like what's happened? Why can't we do that? What's going on?
Yeah, so well, I mean, there's more interesting history here. So the first thing they tried to do, they're trying to pursue removing him to a third country. Then Judge Zinnes says, well, you don't have an actual order of removal in your file, so you can't do that. Now, this was incorrect because basically, like she is a district court judge who doesn't understand how immigration court works. When an immigration court gives somebody withholding of removal, they are implicitly saying you can't get withholding of removal unless you're found removable in the first instance, right? You have to be removable to get withholding. So he was found removable in that first instance. The fact that there wasn't a specific document that said this is the order of removal is irrelevant. But she made that claim, and the reason that's important is because she's jurisdiction stripped if there's an order of removal, right? District court judges are not allowed to review the execution of orders of removal. So she had to say that no such order existed. Then what the DOJ was like, fine. We go back to the immigration judge. Immigration judge issues a quote unquote amended order of removal, and they go back to the court and they're like, "You're done here. You don't have jurisdiction, and we're going to remove him to Liberia is where we want to remove him to. We actually have a verbal commitment from the Liberian government that they're ready to take him." And then, so the most recent opinion of hers is saying, "Well, actually." I don't even know how. I need to look back and how she got past the jurisdiction stripping problem because she really should not even be in the case.
Oh, judges are very creative about getting around jurisdiction stripping, as Kathryn and I know.
Especially in the immigration context. Dear Lord,
what does that mean? You just like how do you pick your judge? What I don't get it.
No, it says the statute says suppose you get an order of removal from an immigration judge. It says you get one appeal to the Board of Immigration Appeals, and then from there you get an appeal to a court of appeals, and usually it's very deferential. And these district judges they don't have jurisdiction. The statute does not give them jurisdiction to review the immigration judge orders, and yet they're doing it anyway. And they're coming up with all sorts of reasons, like I don't know, like well, he's making a constitutional argument, and I have jurisdiction to consider constitutional arguments. Is that what they're saying? Do you know in his case?
That's one of the claims they're making. They're basically saying what they're really saying is this. This isn't about the execution of the order of removal. It's about some other thing related to the order of removal that is not specified in the statute that strips jurisdiction.
So this is like the TPS thing that I wanted to talk about too, where the judge
very
said,
similar. Yes.
Basically, so I'll jump the gun a little bit, but we had that Judge Reyes decision where the Trump administration finally ended temporary protected status for Haiti. And the statute says district judges do not have jurisdiction to review a determination about the continuation or not of TPS status. And so what the judge said was, well, I can have jurisdiction over the question whether the process leading up to this determination was followed, which is utterly insane and not what the cases, actually say that she relied upon. So, Will, I know we didn't get to this, like what's actually going on and why can't we remove them to these third countries, but what is going on with these district judges? Is this just lawfare? Is this just district judges doing this onslaught of things to stop the administration, even though they don't have jurisdiction? And they just know that, as a Ninth Circuit judge Reinhardt famously said, well, the Supreme Court can't get them all, right? Like, what's going on here with these judges?
That's exactly right. It's a straight up judicial rebellion against, and it's not a rebellion against, it's not a separation of powers issue. This is a vertical stare decisis problem, right? They're just not respecting but either the statutes passed by Congress or higher court rulings on point.
No, that's crazy. Okay, so they exercise jurisdiction and they say he can't be removed to these countries. Why? Because of torture?
So he can't be removed to the argument
Liberia.
So this is where we get into Zadvydas, right? And so understanding Zadvydas is important. So let's just talk about that case, wild one, honestly, a big Supreme Court miss. So the facts. Zadvydas was this career criminal who was a displaced person after World War II, I think born in Lithuania, but he was displaced from Germany, never got his citizenship papers settled in those countries when he was a kid, and then was brought to the United States as a refugee, but never got his citizenship settled here either, right? So he wasn't a legal alien. He wasn't a legal resident of the United States, or he might have been, but he might have had it stripped. I don't remember exactly what what's true there. But in any event, basically, he committed a bunch of crimes, and eventually DHS wanted to deport him. So they went to Germany, and Germany's like, "He's not our citizen. We're not taking this career criminal." They went to Lithuania, same answer. They went to even the Dominican Republic, which is where his wife was a citizen. Like, "Will you take this guy?" And they're like, "No, gracias." And so we're back to he's just in immigration limbo because he's been stripped of his right to be in the United States, but he has no other country he can go to. And so then there's the statute that is the subject of, okay, well, the statute actually seems to say pretty clearly that there is this period of, I think, 90 days where they're supposed to remove an alien who's been found removable. But there was a provision that said, and in the proper case, the district, U.S. attorneys can just continue to hold him indefinitely. And this got all the way to the Supreme Court, and the Supreme Court said, well, this indefinite detention without any prospect of being eventually removed to a third country creates possible due process problems. So we're going to do constitutional avoidance, right? We're going to interpret the statute to say that there is a time limit because alternative interpretations would raise constitutional questions. This is bogus because the statute's actually unambiguous, and you're only supposed to use constitutional avoidance when there is an underlying ambiguity in the statute, and then you're picking between two plausible interpretations.
It's unambiguous because it says shall detain, putting aside the fact of the 90-day aspiration.
It's not shall detain, but she shall have the discretion to detain.
Okay.
Right?
But so that seems like such an issue, though. What do you think you do with him otherwise if no country will take him? What's the alternative? I mean, should he just sit in detention in America forever? I mean,
it's not obvious, but it's the alternative is worse, right? Basically, like the guy, the alternative is worse, and the reason the alternative is worse is because it creates a problem whereby migrants who have been found removable have an incentive to not work with the government and try and prove that they can't be removed to a specific country, because then they know that if they just stay in, they can be released into the country despite being a removable illegal alien, which is exactly the problem created in the Abrego Garcia case, right? This guy isn't a legal alien. He has no right to be in the country. He was, crossed illegally and was picked up 8 years later. He doesn't fit into he's not eligible for asylum. He's only fighting withholding of removal because he knows that if he wins withholding, it's a pain in the ass to get him removed to a third country where he's not a citizen. It's a lot of work that it just won't get done. So effectively, by winning withholding of removal, because of Zadvydas, it becomes backdoor asylum, becomes a backdoor way to stay in the country.
I have so many sort of follow-up points and questions. The first of which is, Kathryn, that was so uncharacteristic of you to ask that question. I thought so. I'm going to channel like the Kathryn that I know and love, which is, wait, so why should we have to take him into the country? Like, as opposed, if no other country is going to take him, but we are not allowed, or we don't want to take him, why must we release him into the country? Which is, I thought, Kathryn, what your position would be. Oh, go ahead. You want to defend?
No, it's true. I just don't. It seems like everything is a bad result. Like I get the situation here. It's like it's difficult, but I mean, if no one wants him, there's probably a reason no one wants him. So I don't know. Maybe he should just stay detained. I don't know.
Right. Maybe.
Yeah. And it's a rare circumstance. Like it's a really, I mean, the case where somebody just literally doesn't have citizenship anywhere is a very, very bizarre circumstance.
I just feel like who was president when all this was going down? Clinton?
Like, this was Clinton.
Trump would have turned the screws on the Germans and the Lithuanians, and he would have said, "You want that NATO money? You want no tariffs? Take your citizens," right? I mean, that's really, I guess, what would solve this problem. But I do find it fascinating that there's like a supposed due process problem, because like that's clearly preposterous as a historical and original matter. What you're really saying is, well, the statute says that we can detain you because you're not allowed to be here. No other country wants to take you, or you don't want to go to some other country, which I suppose you could choose at any time. So we're just going to detain you until this is resolved forever. To say that that's a due process problem, even though Zadvydas fell within the category, it was acknowledged to fall within the category that the statute says can be detained. The statute says you can be detained there's no due process problem, right? You have all the process you've been due, unless what we're doing, Kathryn, if you remember our episode on substantive due process, is this idea that there are unwritten limits on what the government is allowed to do, which is preposterous. Basically, what they're saying is it would be unconstitutional for Congress to pass a statute that says we're going to detain aliens indefinitely who aren't allowed to be here if no other country takes them. It's substantive due process. It's not due process. Am I getting that right, Will, or is
Yeah,
there some
and I think
procedural?
I think part of the reason is they didn't want to make that claim, in the Supreme Court, right? Like the principled way for the Supreme Court to approach this was to say the statute's unambiguous, but the statute's unconstitutional. They didn't say that. They got cute. They're like, well, there could be a due process question raised by interpreting the statute in such a way, right? And
Oh,
so
yeah. Don't get me started on the so-called doctrine of constitutional avoidance. Okay. My students know that, like, I totally hate this doctrine and think it's totally made up. So just to emphasize what Will is saying, it's one thing, and it would be consistent with the judicial power to say the statute, if it means X, would be unconstitutional. And therefore, we're going to narrowly interpret it to mean not X, or to mean X minus epsilon, so that it would be consistent with the Constitution. That's fine. But what Will is saying the court did here is, well, we don't know that the statute is going to violate the Constitution. We aren't saying that it would violate the Constitution, but it might. We have a doubt, and therefore we're going to rewrite Congress's statute. That is judicial legislating. That is lawmaking from the bench. That is legislators in robes. The doctrine of not unconstitutional conditions, I'm sorry. The doctrine of constitutional avoidance is totally preposterous as it's done in the modern day. Okay, Will, I want to move on to the other immigration topic, but first, so bring Zadvydas home to us in terms of the Kilmar Abrego Garcia case. So I still don't understand, why can't we remove him to Liberia?
So basically what Judge Zinnes did, again, it's amazing how she always finds a way to keep this guy free in the United States. Let's start there. So she's basically saying, despite the existence of this commitment from the Liberian government to take him, and despite the DHS's commitment that we are going to remove him there, have found it improbable that he would be removed to Liberia, and therefore, because it's improbable, it triggers the Zadvydas problem, where there's this: you can't just hold somebody indefinitely if you don't have if it's not reasonably foreseeable that he will be removed.
This is like Judge Zinnes saying, it is improbable that I will allow you to do this thing that you're allowed to do, and therefore it is improbable that you will do that thing, creating this constitutional problem. Am I crazy? What's happening?
I don't think it's quite that abusive. I think she's just dismissing the actual evidence of commitment from the Liberian government to take her. I think that's what's happening.
Okay. All right. Well, we had a bunch of immigration topics we wanted to talk about. We'd already talked about the temporary protected status thing. So let me just quickly say that the DC district judge who had stopped the Trump administration from suspending the temporary protected status or ending the temporary protected status for Haiti was upheld on the emergency docket of the DC circuit in a 2-1 decision. So we'll see. Again, there's that jurisdiction question, which is super bizarre. And we will see what the Supreme Court does with that one. There's some other stuff in the Ninth Circuit about the refugee admissions program. But I really want to talk about this dissental from Judge Emil Bove, who was Trump's number 3 in the DOJ and then was nominated to the Third Circuit, involving the Equal Access to Justice Act. So first of all, to the listeners or viewers, what is a dissental? Well, a dissental is when most appeals are heard by 3-judge panels, but then you could request that the full court, like the Third Circuit, right, Court of Appeals for the Third Circuit or the Fifth Circuit, whatever court you're in, you can request that the full court hear the matter en banc, or as my judge used to say, in bank, because this is America. So like we don't have to use all these Latin terms. But anyway, so you could petition the court to rehear it as a full court of 9, 10, 11 judges, what have you. And if the court refuses to rehear the case, then some judges can dissent from the denial of the rehearing. And we call this a dissental. And then it goes up, that's a signal to the Supreme Court that, hey, you should really take this case. Okay, so this dissental that I just saw involves the Equal Access to Justice Act. And the Equal Access to Justice Act allows the granting of attorney's fees whenever the government has come after you or sued you or done something to you and you prevail against the government, okay? And the government's position was not substantially justified, okay? So we have these cases arising from the Biden era, where even the Biden administration was trying to detain these aliens. Okay, it involves criminal, illegal aliens, not just illegal aliens. Those who were criminally here. One had this violent, assault and resisting arrest and all sorts of violent charges against him. The other alien in question not only was illegally here, but committed like $4.5 million in fraud. And so the government, so they were convicted. Let's stick with the fraud guy. He was sentenced to time served in 2020. And the Biden administration then tried to detain him pending the removal. And because I think of Zadvydas and cases like it, the lower judges, the district judges or the magistrate judges who are assistants to the district judges, ordered that they be released, even though like you're criminals, we're trying to deport you. There's no reason to think that you're going to, show up. And so they ordered them released and concluded that their detention was unlawful because of due process or whatever. And I guess that the government's position was not substantially justified in detaining them, which is also kind of insane. So not only are they released back into the country, and hopefully they'll show up when we finally remove them, but we, the United States taxpayers, had to pay their attorney's fees. Okay, and so this is the setup, okay? And so the question here, I guess there are two questions. The first question is on the, I guess, the statute, Equal Access to Justice Act, applies to civil actions, any civil actions. And there's a question of whether a habeas petition is a civil action. We've talked, Kathryn, right, about the habeas corpus before, how to pronounce habeas corpus and how I was made fun of in law school for mispronouncing habeas corpus. Basically, a petition to have the government release you, to produce the body and justify the detention. Is that a civil action is sort of the first question. But the more crazy question is, how is it possible that the government's position is not substantially justified such that it would defeat an attorney's fee, an attorney's fee claim, right? I mean, do we have some of the facts in this case? I think we printed something up from the Amo Bove opinion. Okay, so here we have the violent one. It's just absolutely crazy what he did. Okay. Kathryn, do you have it? I think I'm getting there. Here we go.
Yeah, so he was, while remaining in the United States without authorization, he was arrested several other times for offenses relating to narcotics, aggravated assault with a firearm, and aggravated battery on a pregnant woman.
Charming.
And then we ordered him removed, but then he absconded, right? This is all from the Bove dissental. And then he got another arrest. So after he was arrested, ordered removed, and absconded, he got another arrest for a violent crime. And then the Biden administration, can I just emphasize that for a second? The Biden administration said, you know what? I think we should detain you. And in fact, we should detain you before we remove you. And so not only did the judge say, well, actually, even though the statute allows you to detain, and I actually wonder if it says shall detain in this part of the statute based on certain offenses, but so not only does the statute at least allow you to detain and possibly actually say you must detain, but actually we think there are due process problems and there's no reason to think he's a flight risk. He didn't show up the first time.
He's already absconded.
Yeah, already absconded the first time. And you found him again when you arrested him on another violent crime charge, right? But anyway, so not only do we release him, but because the government detained him unconstitutionally, because the statute violates due process, I guess, we, the taxpayers, have to pay him his attorney's fees. Isn't that insane?
It's insane enough to release him. It's, one of the many things I think, there's so many insane things here, but really, first off, bail for these people just as a default is insane, right? That's the whole discussion about this Fifth Circuit opinion that came down recently, right? If you're an illegal alien, you don't have a right to be in the country, right? And everybody agrees you don't have a right to be in the country until you are eventually maybe granted asylum or withholding. So why do you get to go out on bail in the interim? Bails for American citizens who have a right to be in the country until they're convicted of a crime. You don't have the right to be here. Everybody agrees that.
So if the Fifth Circuit decision is upheld by the Supreme Court, does that actually solve this problem? We took a deep dive into. I'm not sure.
It doesn't solve it for everybody because I think the Fifth Circuit opinion only applies to the class of aliens who never presented themselves at a port of entry, right? So there's illegal aliens who are here, but they're visa overstays, so they did present themselves at a port of entry, and so they wouldn't fit into the category of people who could just be detained without bond, or so instead of
who
shall be detained without bond.
I see. So instead of 8 USC 1225, those cases would be 8 USC 1226, which is actually gives more discretion, it seems to me, to the government to detain them. But your point in the Zadvydas opinion and other cases say discretion or not discretion, shall detain or not shall detain, doesn't matter. There's this due process limit. You have to have these bond hearings, which is just sort of crazy. Okay, I want to read one other part from the Bovey opinion.
Yeah.
Then I'll say something about civil action, and then we have to talk about our next topic, which is law firms. Before we stop, the Kilmar Abrego Garcia. We wanted to take a deep dive with Will.
There's so much there. There really is so much there because it's been going on so long, and it's like amazing how one single case could just reveal so much wrong with our immigration law. Like
it's crazy. And this dissent reveals more. That's crazy with our immigration law. So here, I just had to read this. So the second petitioner, this is from the Emil Bova dissental. I can't even, Aduwumi Abioye. Okay, I'm going to, so Abioye overstayed his visa, appears to have attempted to obtain citizenship through marriage fraud, and perpetrated a massive financial fraud in this country that caused 4.6 million in losses to more than 10 victims. He admitted that 1.5 million of the fraud proceeds went to accounts that he controlled. Abioye had not completed his supervised release component of his sentence at the time he argued in his habeas proceedings that his continued detention was unreasonable. And his sentence also included orders to pay millions of dollars in forfeiture and restitution. In effect, the fee award in this case under the Equal Access to Justice Act directs the government to pay him instead. So can we say, okay, fine, we'll give you attorney's fees, but we're actually deducting it from the millions of dollars you owe Americans for having defrauded them? Like, at least you should say that. Okay, one point on the legal thing, and then let's move on to this law firm stuff. Is a habeas proceeding a civil action? The argument that Judge Bove makes is that civil actions, the federal rules of civil procedures say there shall be one form of action, the civil action, and that's it. But of course, there are non-civil actions. There are criminal actions, right? So when we say the one form of action, the civil action, where does that come from? Well, historically, at common law, you had to file very specific writs, very specific actions. Like, this is an action on the case, or this is an action for a writ of replevin. And if you didn't file the exact case with the exact writ in the exact form required by the common law, then you would be kicked out. And so in 1930s, we merged law and equity. We merged all these causes of action, and we said, there's one cause of action, the civil action. The federal rules of civil procedure apply to all of those actions. You file a complaint, you can make your claims. That was the point of it. But it doesn't tell us what is a civil action as opposed to a criminal action or as opposed to something else. And what Judge Bove says is that habeas proceedings the federal rules of civil procedure don't apply to them. It's not started with a complaint. It's started with a petition. And the petition is governed by federal law, very distinct from the federal rules of civil procedure. And so his argument that it's not a civil action, and I guess what other people say on the other side, I suppose, would be that there are criminal actions and there are civil actions. And that's how the world is divided, and this isn't criminal, it's civil. But I tend to agree with Judge Bove that I think the world doesn't neatly divide into just civil and criminal. There could be other things. There could be administrative. There could be habeas.
And it's also, I think, that remember that the other big point is that since it's Equal Access to Justice Act and it's about sovereign immunity and the government paying you money and your entitlement to money from the government, there's the first idea that the government must speak clearly when it's actually ceding its sovereign immunity over something. So if there's some ambiguity here, there's some question about whether habeas constitutes civil action, then you default in favor of the government whenever it comes to something like attorney's fees paid by the government.
So there's got to be, the Supreme Court has got to grant this, right?
I would assume. Yeah. This sounds like based on what I'm reading, I'm not deep on this literature at all. I just, I actually, you flagged it for me and I read about it early this morning, but having read the opinion, in brief, I'm like, yeah, this sounds like it's going to get reversed. And this also, habeas in particular, whenever I just remember the Supreme Court has had to slap down so many appellate decisions on habeas that it's the same problem. The funny thing is it's all unified by the problem of district and appellate court judges wanting to do things that Congress is saying, please stop doing this. And habeas is another example. Please stop giving out habeas randomly to everybody. We're literally jurisdiction stripping you. You can only do it in these extremely narrow circumstances. And the judges are like, la, 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 we don't care. Go free.
The local angle here in Minnesota is our, district attorney or our state attorney out of Minnesota, Dan
U.S.
Rosen,
attorney. Yeah,
U.S.
U.S. attorney.
Attorney, thank you, Ilan. U.S. Attorney Dan Rosen, he is being threatened to be held in contempt by a judge because multiple judges because of all these habeas cases. And the thing that they're complaining about basically is that they like lost some of the detainees' stuff in the way. And so this is like a horrible, horrible thing that the government has done, including like one shoelace from a guy, and that's why they're holding him in contempt of court. The actual U.S.
Yeah,
attorney.
so is this, Kathryn, I can't remember, is this the whole, there was this judge who said, the Trump administration has violated 80 orders, from
Hmm.
this court about habeas. But I think this was
Yes.
a different judge who threatened to hold Dan Rosen himself in contempt, the U.S. attorney, for violating these court orders. And if you actually listen to the proceeding, it was like 5 cases ultimately that maybe they had violated. And one of the case was the shoelace, like we
Yeah,
lost
the
a shoelace.
violations are like, or the guy, they're waiting for the lawyer to come pick up the guy's passport. And they're like, we will put you in jail unless you give him his passport back. And they're like, we're waiting for the lawyer. I mean, it's just crazy. Clearly, the judge is on some sort of like, ego trip or something where he's just so incensed by what's going on and is just so anti-Trump that it's like whatever he can do, I think,
Well,
is
this
their
is great.
MO.
And next weekend, there's a big conservative law student conference, and I am debating, or was supposed to debate, though it's a little trouble finding a debate opponent for me. But put that aside, the proposition that district courts are a threat to the republic. And okay, it's kind of cute, the way we asked it, but this is giving me some fodder. So I guess, Will, the through line here is that judges and immigration lawyers are kind of out of control. And okay, but are law firms out of control? That's the last topic I guess we want to talk about today. And the setup for this is there was some crazy development in the executive order respecting law firms. So you'll remember that when Trump assumed power again a year ago, he issued these executive orders basically revoking security clearances and government contracts for all these super liberal white shoe law firms who routinely litigate against the Trump administration, routinely litigate against Republican ideas and ideas that half the country sort of agrees with. And some of the firms were involved in like the 2016 Russia stuff, which is I think was particularly sensitive. So he issued these orders. Almost every big firm settled, right, with the administration. And like whatever, it wasn't like they promised like to do a little bit more pro bono for conservative causes. God forbid you show some
Yeah.
impartiality, like when it
Yeah.
comes to
Unthinkable,
providing
right? Yeah.
billions
Uh,
of dollars of in-kind contributions to like one party. Like it's just through pro bono legal services. So, but four law firms persisted. Um, one of which is Perkins Coie, and I think Wilmer Hale was another one. And so, not surprisingly, the four district judges said this was unconstitutional, a violation of what, the First Amendment, I guess. And so there's some interesting law there to discuss. But this all was consolidated, went to an appeal at the D.C. Circuit, and the DOJ lawyer entered into a voluntary agreement to dismiss the case, to withdraw, that we're not pursuing this appeal. And 3 days later, the DOJ came back and said, nope, just kidding. We are pursuing this appeal. Like, so I have no idea exactly what happened, but this is in the news again. And I suppose I wanted to get your sense on like what is going on with these law firms. I have some stuff I want to say on the legal element of it, but like, I don't know, isn't Trump, this is probably the most base thing I'm going to say today. Don't the law firms like need to be brought to heel in some respect?
yeah, they do. The thing about the Abrego Garcia case, it really, this isn't a criminal case. He doesn't have a right to an attorney, so this is all optional. Like he's not, I mean, he does have a criminal
Mhm.
charge in Tennessee, which of course, obviously he's entitled to legal representation, but he's not entitled to legal representation in his habeas proceedings, I think. Um, and
Or
yet,
certainly not in the removal proceedings and
yeah,
all
yeah,
that stuff.
yeah. So the fact that I mean, my old firm is Quinn Emanuel. There are like 6 Quinn Emanuel partners on the briefs in the Abrego
On
Garcia
Kilmar?
case. Yeah, on
In the
Kilmar.
Kil Wow, Quinn Emanuel, 6 lawyers.
Yeah,
Oh
like
my.
a slew of partners. And I'm like, the
And
amount
they
of,
just do that pro bono
yeah, they're just
most
doing
of
it
the
pro
time.
bono. I'm sure this is their pro bono work because there's nobody, like there are nonprofit, immigrants' rights firms
Mhm.
that do this stuff and, do it pro bono for migrants. But Quinn Emanuel Quinn Emanuel is not getting funded by nonprofits to do this stuff. Quinn Emanuel's a massively profitable law firm independently. So it's just, this is the lawyers doing this pro bono. And Quinn Emanuel not taking any money for it. Like, why? What is, there aren't more deserving targets of pro bono representation than an MS-13 gangbanger who, beat his wife. Like there's the
There
allegation of
are.
him beating his
There
wife,
are.
human trafficking people. Like you don't have
Will,
any better idea how to spend your time?
there are better ways. Gitmo detainees, defending
Right,
them.
right. And yet nobody, and this is a big bone I have, not a single one of these people dared take a January 6th defendant. Not one. And there were serious constitutional concerns. I mean, the J6 defendants won a bunch of cases at the Supreme Court that were being brought by, lawyers taking money because that's the only people who would represent them. But it wasn't, certainly the big law firms were nowhere to be found with the J6 defendants, many of them in their own city. And they could have been there to help protect people from like overweening abuse by DOJ, but no, not there. They're
I
just
have
untakeable.
There are firms here that will, they require you to do a certain number of hours for diverse causes or diverse clients. That's like a certain number of billable hours you have to have. So if it's a white person, it's like, man, it doesn't really count for as much. Sorry, I'll pass on the J6 guy, but I'll help Bill Brego because that's just insane.
so
That
someone
strikes me
who's
as
being
something Harmeet Dillon should know about. I don't know if she does know about that. Well, you should
I can tell her about
like
that. There's at least one firm in
flag the
Minneapolis.
details of that for me, and I'll get it to Harmeet's attention.
I will.
That's something I'll do.
that's crazy. And like I have some personal experience with this on the homelessness front. So as our listeners kind of know, I've hinted at this before, and one day we'll talk about this in more detail. I have this litigation practice on the side where I sue municipalities over public homeless encampments under public nuisance theory. And we've won in a couple of these cases. I've got this big trial going to Berkeley. But what's fascinating about this is the number of big law firms that always go on the side of the people who are camping and obstructing even like legitimate city attempts to remove them. So in San Francisco, there was this whole big to-do when Latham and Watkins represented, I think it was called the Coalition for the Homeless, where they basically, the city of San Francisco finally, for the first time in years, said, okay, we actually need to do something about some of these encampments. They're like really bad. And these big law firms just represented this coalition that basically prevented the city from doing it. Where are the big law in Phoenix? In the case that I won in the in state court, there was a parallel filing in federal court to try to get the city to not clean up the 800-person homeless encampment. And our big law firm, the biggest law firm in Arizona, Snell and Wilmer, represented them along with the ACLU. And I'm like, wait a minute, what about the mom and pop sandwich shop that I'm representing on my own? Any big law firm want to help me with that? Like,
No.
not a single one. And then it comes to something that I posted about on X after the birthright citizenship case, which again, I'm here to testify about that today. And I filed an amicus brief in that case. Not a single white shoe law firm filed a brief on behalf of any organization, right, or person supporting the Trump administration about this, but they sure as heck did in the support. They filed Wilmer Hale, one of the four firms that is being targeted by the EOs that has not settled. They represented Catholic Social Services, or what's that group? Catholic Conference of Bishops, or
Yeah, Catholic Conference of Bishops, I think, yeah.
and so which led me, so this guy Wilmer Hale tweeted. Posted. I was honored to file an amicus brief today in the birthright citizenship case before the U.S. Supreme Court, expressing the view of the Conference of Catholic Bishops that the president's executive order is contrary to Catholic social teaching and immoral. First of all, what? It is immoral to not have a birthright citizenship rule, or one that doesn't extend to illegal aliens or people who are temporarily, totally, utterly insane. And so then that led me to post the following, which was, here's a white shoe law firm filing a brief invoking an interpretation of Catholic teaching to support expansive birthright citizenship, even though not a single one, white shoe law firms, filed a brief in support of traditional marriage in the 2015 Obergefell case. Fascinating. So you'll represent Catholics when they want to file a brief that advances these progressive liberal causes, but you won't represent Catholics. You leave them to fend for themselves when they support traditional marriage. Of course, not a single white shoe law firm filed a brief in support of traditional marriage in 2015, all of which brings me back to the point, Will, Kathryn, putting the legal stuff aside, which I do want to touch on that before we let our listeners go here. But these law firms, this is a real problem. This is a real problem. And I don't want to sound too radical, but I'm pretty radical on this, I think, which is a society is unsustainable when the elite law firms, the elite legal services provide billions of dollars in free legal services, in-kind contributions to a particular political viewpoint that less than half the country actually supports. Doesn't that just help perpetuate anti-democratical oligarchy, aristocracy? It's unsustainable isn't it good that we do something about it, whether the EOs are the right answer or not, we can come back to. But am I crazy?
No, you're not. And I mean, you could. This problem starts in the law. It's in the law legal academy. It's everywhere. I mean, the fact is that like both the legal academy and white shoe law firms, like basically that is, call it the cathedral if you wanted, the legal cathedral. They're inexorable. They're completely left wing. And if they're just an arm of the Democratic Party, then I mean, obviously it connects to legal questions. Why should a Republican administration just treat them, as though they're these nonpartisan corporate entities? They're not. They're part of the Democratic Party. They want access to classified information. Well, we can't trust you with it because lefties leak on righties. Sorry.
That's interesting.
Right? Like, why should we trust you with classified? Why are you entitled to see classified information given the conduct of these hard left-wing lawyers over the past decade against President Trump? I think that I had a whole debate on this subject with George Conway actually at a FedSoc event. I mean, FedSoc doesn't record them, so I don't, it's lost into the ether. But, I think my fundamental point, and I never got around to this, where people were making this like, well, it's the First Amendment, you're punishing them for their speech. I'm like, can there really be any justification for a judge coming in and telling the president he needs to let somebody access classified information? Like if the president deems it not in the interest of the country?
Well, it's like firing someone almost too, isn't it? I mean, okay, so sorry you can't come in during this administration. How is that? Like, what's the legal issue here? It's they have a right to do this?
So,
classified information?
A great question, and Will already set up part of the legal answer. So the legal framework here is the following. There's no right to government contracts. There's no right to government employment. There's no right to a government security clearance. They're what we call privileges. They're public privileges, and you're not entitled to it. But there is a doctrine of constitutional law, which is sensible most of the time, right? Where it says you don't want to condition the receipt of government benefits on people forgoing constitutional rights or other rights if they are otherwise unrelated to the purpose of the program, right? So you don't want to say, hey, we'll give you Social Security benefits if you give up your guns, right? Because there's no connection between guns and Social Security. We don't want to say, hey, we'll only give you lucrative government contracts if you voted for us in the last election. Like, as a general rule, we don't say that. And it's called the doctrine of unconstitutional conditions. But if the condition is related to the purpose of the privilege in question, then the court does routinely allow Congress or the president to condition receipt of those benefits. So, for example, there are cases from the 70s that say the government can require you to let them in for suspicionless welfare home searches, which would otherwise violate the Fourth Amendment if you want to receive welfare benefits, because there's a connection there. Government employees lose First Amendment rights at the government building door, right? There's a whole case about, about this, Will, the kicking out students for speech. And FIRE filed this lawsuit, foreign students. And FIRE, Foundation for Individual Rights and Expression, I think they call themselves now, like filed the suit saying it violates the First Amendment. Well, are you telling me we have to accept into our country people who spew hateful things and want to destroy this country? Of course not. So the question here is the condition that's, reasonably related to the purpose of the privilege. And Will, I think you answered it. You said security clearance are really important. If you just come back and turn it around and use it against my administration, and if you leak information and we can't trust you for whatever reason, like, why should we give you access to that if all you're going to do, rather than be impartial and impartial arbiter of the law, is represent clients whose sole goal is to undermine my administration, including the legitimate things that I'm doing? That does seem somewhat related, doesn't it?
Yeah, and I mean, I think also you got to think back to, how did these places abuse classified information? How do they abuse a lot of what they were doing? I mean, if they were involved in Russiagate, I mean, for example, like Perkins Coie is the classic example of this, where Perkins Coie was used to launder all the conversations related to the Russian dossier, the Steele dossier. That was totally fake. And that was definitely, I'm pretty sure they were getting some classified leaks as a part of that too. So, yeah, I mean, yeah, it's, okay, how can the Trump administration, after what Perkins Coie did with Mark Elias back in 2016, trust that Perkins Coie will handle classified information appropriately? Why are they forced to do that? And again, because classified is such a discretionary thing, like the statute creating the whole classification structure vests all the authority to classify or declassify in the president. And so if the president says, no, these people don't get classified, The idea that Article 3 judges could come in and say, no, Mr. President, you have to disclose our nation's secrets to these people. That can't be right. It just can't be.
So we are nearing our hour here. Actually, we're a little past it. Will, this has been a great conversation. We're going to have you back to tease what I want to talk to you about in a future episode. So on our last episode, Kathryn and I debated whether international law was real. I think it's real, but the UN sucks and doesn't reflect international law. And there was this thing called international law before the United Nations. Kathryn, what did you say? It was fake and dumb?
Fake and dumb.
Fake
Yeah.
and dumb. Yeah, that's her clip.
Where do you stand? Like briefly, where do you stand, Will?
I think international law is the B-2 bomber. That's what the international law is.
Threats backed by force.
What did Schmidt say? The sovereign is he who decides the exception. Well, nobody can enforce international law against us. So we are sovereign over international law, and we say what international law is because we have the United States military.
Yeah.
I love that answer. You can come back whenever you want, Will. That's perfect.
Hey.
Yeah.
So yes, you in fact can, even though you and Kathryn could tag team against me on this John Austin versus HLA Hart, but definitely a discussion we want to have in the future. But we were so grateful to be able to do this deep dive into the Kilmar Abrego Garcia case and immigration in general. Will Chamberlain of the Article 3 Project, thank you so much for joining us. To our listeners, our next episode will be our live taping with the most conservative students, law students in the nation. We're going to do that later this week, so please stay tuned for that. And as always, like, subscribe, follow us, share spread the word, and we will see you next week.